I'm Kristen Smith, as Kathy said, and I wanted to first just give an update as I have the last couple weeks on the next slide. Not really an update, but a plug for our fall breakfast briefing in the Labor and Employment Department, where we're talking about laws that pertain to pregnant workers. We do have a couple of sessions left. Albany, Saratoga, Syracuse, and Westchester have not happened yet. So if you're in those areas and you haven't registered yet, highly recommend it. It's a great session, very interactive, very practical, and some really new information from federal law that many people would not yet be familiar with. So recommend that you check that out. So with that, let's tell you what we got today on the webinar. So the agenda today is very diverse, I would say, in terms of the types of information we're going to be sharing. A lot of times when I'm here hosting, you'll hear a lot about labor and employment. This week, not quite as much. So we're going to start down in New York City with our member, Mark Berman, who's going to talk about new AI guidelines. I feel like AI is one of those subjects, Mark, where there's no shortage of things to talk about. After we go to Mark, we're going to hear from Nick Jacobson with some labor and employment litigation updates. Nick joins us once a month to share some updates in that area. Then we'll talk with Catherine Herbeck, an IP lawyer in Syracuse, about blockchain. I'm going to learn a lot because I don't know what that is at all. And then we'll go to Haley in our Syracuse office as well, talking about commercial financing. So quite a wide variety of topics today, hopefully something for everyone. But Mark, can you start us off talking about the latest with AI?
Yes. Good afternoon. Mark Berman, former chair of the litigation section for the State Bar, as well as on the AI committee for the Second Department. AI is the watchword. Everyone's talking about it. Maybe people are getting sick of it, but there's some new guidelines out there. And I wrote an article in the New York Law Journal last month on the new ABA guidelines. And I just thought, for Christian's program today, for the lawyers and the business people out there, it really raises some interesting issues that everyone should be focusing and aware of, and not really the typical stuff. It is ABA Ethics Opinion 512 that I'll be speaking about. We've all heard about the duty of competence with technology. We've all heard about the duty of confidentiality, and we'll talk a little bit about that. But a little bit different, the opinion focuses on what lawyers need to disclose to their clients, as well as, what testing for generative AI, the processes, what comes in, what comes out, and what do you really have, what kind of due diligence do you have to do? And I think that's what clients and lawyers really do need to focus on now. The opinion begins and titles something that is somewhat obvious to people, given the quality, breadth, and sources of the underlying data on which a generative AI tool is trained. There are certain limitations. At times it's outdated, sometimes it reflects biased content. The tools may also produce unreliable, incomplete, or really in certain circumstances, discriminatory results. So what does that mean? That means lawyers and clients who use generative AI for business or legal purposes have to think twice, have to think 3 times, not to use it, but how to be able to be confident and to check whether the information is accurate and how it's being used, because you could get into some hot water. But on the good news, the front, the ABA opinion says if a lawyer is using generative AI to review and summarize, for instance, lengthy contracts, the lawyer would not necessarily, and they use the word necessarily, have to manually review the entire set to verify the results, if the lawyer has previously tested the accuracy on a small sample. So that is the good news. We're not talking about those high-profile cases where you have cases that don't exist. This is more run-of-the-mill use of AI, in reviewing and drafting contracts. So you have to do a sample testing to make sure everything's right, but you don't have to reinvent the wheel and review everything, Because if that was the case, no one would be saving any money using AI. Everybody has heard about confidentiality. If you use AI, public AI, information goes in and the whole world is knowing about it. But law firms and clients are developing and purchasing their own AI packages or platforms that are not public. So people can feel confident and comfortable that the public is not going to get the information. But no one thinks about internally. You're a big company, you purchase this platform, and you put your information in for client A, project A, and the next lawyer or business person uses the AI and seeks results. And these are confidential projects or clients. And internally, within the business or in the firm, does the output provide confidential information about that prior project or that prior client? Everyone is sensitive to the public issue. But one really has to now, because we've gotten over that hurdle, internally within the law firm, within the business, to ensure that there's not a cross-mix, cross-fertilization of private and confidential proprietary information between two different projects that were both inputted, and then you get the output. That's something really people have not focused on. Next area, which is difficult for the lawyer, is the client consent. It is the client what does the client have to know about the lawyer's use of AI? Because but the opinion goes, it depends on the use, the extent of the use, the specific use, but there are risks all involved with the use of AI. So what has to be disclosed? The ABA opinion goes on to say boilerplate provisions in engagement letter may not be sufficient disclosure because of the uncertainty of the risk, that it needs to be more fact specific, use specific, because what goes in and how it comes out is something that the client needs to know. The issue of disclosure, and the opinion goes on to say, is a fact-specific inquiry. Depends on the use, the importance, the need, the privacy. But and the significance. If you're using AI in a significant, perhaps litigation, to evaluate potential litigation outcomes or jury selections, the opinion goes on to say a client would reasonably want to know you're using AI for that purpose, and to ensure that the lawyer is engaged in independent judgment calls. Those are the highlights, Christian. It goes on in other areas, but I thought it's the client consent, doing your due diligence, and worrying about the concepts in-house and not public that people really haven't focused on out, and that hasn't really been discussed in news. So I thought it's that aspect of the opinion that lawyers and clients should be now moving to focus on, because people are getting comfortable, but there's still more issues out there.
Okay, well, thank you for that. On this webinar, we have lots and lots of clients. So I'm sure they're interested in hearing the perspective of how we should be working together when when we start to venture into this territory. So very much appreciated, Mark.
Thank you very much, Christina, and a pleasure. And if anyone has questions on AI, Bond is free and available to give you assistance in your AI issues.
Great. Great. So Nick, we're going to move to Nick here, up here upstate. I was going to say here in Syracuse because he spends half his time in Syracuse and half his time in Rochester, but looks like you're in your Rochester office today, Nick.
I am. Thanks, Kristen.
Anyway, so like I mentioned before, Nick joins us about once a month and gives us an update on some interesting litigation matters. So what do you have this month for us, Nick?
So next slide, please, Kathy. So the first case that I wanted to talk about today is actually an action commenced by the EEOC against an employer, A-Care HHC, which is a home healthcare company doing business as Four Seasons, and they're based out of Brooklyn. The EEOC brought an action on behalf of Black and Hispanic home health aides employed by Four Seasons. The EEOC alleged that Four Seasons engaged in a pattern and practice of discrimination by reassigning home health aides to accommodate the racial preferences of clients. So if a client made a request, for example, for a white home health aide, the EEOC alleged that Four Seasons was taking action to accommodate those types of requests. The EEOC conducted an investigation that determined that there was reasonable cause to believe Four Seasons was violating the law. And after the investigation, it engaged in conciliation efforts. But when a resolution couldn't be reached, it commenced an enforcement action in the Eastern District of New York. Next slide, please. So, as I mentioned, the EEOC alleged that Four Seasons was accommodating requests to reassign home health aides based on the racial preferences of clients. This allegedly resulted in a disproportionate number of Black and Hispanic aides being removed from assignments. And the EEOC alleged that aides could go weeks or days without an assignment after being removed, and that some aides were never given a reassignment and were instead terminated. And they also alleged that Black and Hispanic aides were forced to care for clients in worse neighborhoods, leading them to have longer and more dangerous commutes. Next slide, please. So generally, when I report on litigation, I'm reporting on a decision that we've gotten either from a district court, a state court, or an appellate court. Here, however, there wasn't a decision from a court in this case. Rather, Four Seasons entered into a consent decree, which is essentially a document memorializing a settlement with the EEOC. And in doing so, they agreed to pay $400,000 to class members who were affected by Four Seasons' alleged practices. In addition to the monetary relief it agreed to pay, Four Seasons also agreed to significant non-monetary relief, including issuing a policy prohibiting race-based assignments, implementing the tracking of client reassignment requests, providing 2 hours of interactive training for all employees with authority to make home health aid assignments, and also complying with extensive reporting requirements related to reassignments and other activities by Four Seasons. Next slide, please. So some important takeaways from this case. The first and most important one, Four Seasons here, assuming that they engaged in the conduct alleged, would have gotten themselves into trouble by accommodating essentially the discriminatory preferences of its clients, which is exactly the opposite of the employer's duty to prevent and remedy discrimination and harassment by third parties in the workplace, including by clients or customers. So, of course, what they shouldn't have done is made race-based assignments in response to the request of clients to do so. Instead, they should have notified clients that such conduct would have been in violation of the law and that there was no basis for them to make reassignments based on race. Another important thing to take away is that employers engaging in patterns or practices of discrimination can face enforcement actions by the EEOC. Typically, the EEOC doesn't get involved when only a single employee's claims are involved, but here where it's a pattern and practice affecting a widespread group of employees, the EEOC is much more likely to get involved. And also, if you've got pattern and practice discrimination issues, then you've got the potential for increased financial exposure because you're going to be potentially facing a class action or collective action type lawsuit that's brought on behalf of a wide range of employees. Another thing to keep in mind is being aware of the potential for disparate impact claims. Here it's clear that the allegations dealt with disparate treatment, treatment of a group differently based on their race in the workplace. But the EEOC imposed monitoring requirements here that really indicate to me that they're concerned about a disparate impact claim, because now they're requiring Four Seasons to track reassignments generally in case customers who are told that they can't have a reassignment based on their racial preference might try to come up with different reasons to request reassignment, and those requests might have a disparate impact on employees of certain races. So even where race or another protected characteristic isn't the basis for an employer's decision, employers should still be mindful of the potential for a disparate impact claim if a certain protected group is disproportionately affected by an employer's decision. Next slide, please, Kathy. So the second case I wanted to talk about today is a district court case out of the Southern District, Bryant v. Buffalo Exchange. This is also a class action lawsuit, and it's brought on behalf of retail employees alleging violation of New York Labor Law 191. Among other things, New York Labor Law 191 requires manual workers to be paid on a weekly basis. The plaintiffs claim that each time they were not paid wages on a weekly basis, that they were effectively underpaid wages. Now, this case is particularly interesting because there's currently a split in the New York State appellate divisions as to whether employees have a private right of action to bring a lawsuit under Section 191. Currently, we're awaiting resolution by the New York Court of Appeals. There is a case pending, and we're awaiting a final decision from the Court of Appeals at this point. Next slide, please. So right now, the two cases where there's been the split are Vega and Grant. And Vega was decided by the First Department, and the First Department held that the moment wages are not paid on time, there has been an underpayment. And the First Department found that where timely payments are not made, double payment is the appropriate remedy. And the court also found that employees have an implied right of action under Section 191 and can sue directly for recovery. Then we got Grant earlier this year out of the Second Department, which held that employees were not underpaid simply because they received their full wage a week later than 191 requires. And the Grant court also found that there is no implied private right of action for employees to commence suit against their employer under Section 191. Next slide, please. So the court in Bryant noted that when there's a split in appellate authority on an issue of state law like here, that federal courts must try to predict which way the Court of Appeals will hold. In Bryant, the court noted that almost all of the district courts have sided with Vega, and they collected decisions that were 5-2 split on the side of Vega. Personally, as an attorney, I don't know if that's almost all, but certainly the majority of courts have, unfortunately for us on the employer side of things, have sided with Vega. And the court in Bryant came out that way as well. It held that manual workers have a private right of action under Section 191 and are entitled to double payment where they were not paid wages on a weekly basis. Next slide, please. So where does that leave us? The first takeaway here is we want to make sure manual workers are being paid on a weekly basis. And the definition for what constitutes a manual worker is very broad. If you have any questions about whether some of your employees qualify as manual workers, I would very much encourage you to reach out to your attorneys at Bond so that you can avoid looking at a class action lawsuit like this yourself. Other than that, at this point, employers really just need to cross their fingers and hope that we either get one, a favorable decision from the Court of Appeals adopting grant, or two, that we get action by either the legislature or the governor. Earlier this year, there was talk of measures being implemented by the governor in the budget process. Governor Hochul apparently agrees with our office that this would be, an unfair windfall to employees who have been paid their wages, just some of them coming a week late, and this would really be a windfall, essentially allowing them to get paid twice. So really, at this point, we're hoping for a favorable court decision or action by the legislature or the governor, so that employers aren't forced to pay employees twice where they might just have paid them a week late in the past.
Great,
And
thanks.
that's the update for today.
Got
Thanks,
it.
Kristen.
Thanks, Nick. Thanks so much. Couple things I wanted to mention there. One is this topic of manual workers and this right of action is one that we've talked about on this webinar before. There was actually legislation proposed by the governor in last year's budget package that would have adopted the position in grant, but it didn't survive the legislative process. So that's definitely something that we're looking at. We had a Q&A here about the first case you talked about regarding racially motivated requests from residents. I know that when I saw that news report, I thought that's something that our clients definitely run into. I've seen it. And the question was posed, what about gender-specific requests based on toileting or showering? I don't know what you think, Nick. I mean, my perspective is that's a different type of request. I think that there's this exception for bona fide occupational, qualification. And
Exactly.
yeah, I think a
So
gender request is different than a racial request.
right. So there are certain circumstances in the law that recognize when gender or other protected characteristics might be a basis for staffing decisions. And my guess would be that that is one of the times where that would apply, right? Because there's a privacy interest in the client to be cared for by someone of their own gender. So I'd want to research to confirm that, but my feeling would that would be one of the types of exceptions to that rule where you could assign someone based on gender because of the needs of the work to be done.
Yeah, that makes sense to me. A lot of questions about that particular topic. Another question is whether there's a minimum number of employees on staff that this applies to, and I think the answer is no. I mean, if you have a manual worker, manual workers have to be paid weekly. It doesn't really matter the size of the organization. Also, a question about public agencies. I don't think this applies to the public sector.
Well, I don't believe it does either.
No. So this is a private sector issue for the manual workers. So all of you in state agencies or local governments, you're off the hook on this one. You don't need to worry about it. Great. Well, thank you so much, Nick. Obviously, great topic since garnered some questions. We'll see you again next month. Okay.
Thanks, Kristen.
All right. Completely different here, but also equally interesting. We've got Catherine Herback, who, like I mentioned, is an intellectual property lawyer. She's an associate here in our Syracuse office. And Catherine is here and going to walk us through the basics of blockchains. I can't give any more of an introduction than that because I don't even know what a blockchain is. So that's why we're going to listen.
Yeah, so I am going to present on the technical aspects of blockchains, going to keep it really simple, really high level, but I think it's really important as this technology becomes more prominent in our lives that a base level technical understanding is achieved. I was an engineer before I was an attorney, so understanding how technology functions, I think, is really important to determine how we move forward using it. Next slide, please. So this is just going to be a very brief introduction to the technology behind blockchains, just what is a blockchain, how are they structured, how are they secured, and how are they used. Next slide. So the one thing I want to start off with is there's no such thing as the blockchain. There are many different blockchains. For example, you've seen like Bitcoin, Ethereum, Solana. Pretty much every time you see a different type of cryptocurrency, they are running on a different chain, which we'll get into what a chain is. Essentially what a chain is, though, is a decentralized distributed ledger. So it is a ledger of information that is stored in multiple locations. Every location has the same information, and it spreads out security, it spreads out transparency, and they are also immutable. So once something is recorded on a chain, it cannot be changed. It is there permanently. This is just so that way there's, like I said, security, immutability, transparency. So rather than, say, a traditional bank where you have a ledger like kept by Bank of America, and Bank of America is the keeper of that ledger, they're the only ones who can add, they're the only ones who can remove. This is run pretty much by the public through a consensus model, and allows, you know, less opportunity for a single point of failure. Next slide, please. So there are three main components to a blockchain. There are blocks, which are made up of data. They are basically what you look for when you're saying what happened. You know, did I buy Bitcoin? Did I pay for something in Bitcoin? What data has been immortalized on a chain? That's stored in the blocks. Those are made up of data, the previous block's hash, and a nonce. We'll go into what each of those aspects are. There's the chain itself, which links blocks in chronological order. So as data is generated, it goes onto the chain as it's created in a linear fashion, one by one. So that way you can see when you go back exactly when things were created or happened or, you know, transferred. And it's a clear time picture, one by one. So that way there's order in the system. Nodes are the pieces that validate and store the blockchain. These are literally servers that they host the entire chain on it. So every time a block is added, it goes to a huge number of servers. All of them have the exact same information on them, and they are stored, and they constantly communicate with each other to make sure that they all say the same thing, which is part of the security and immutability aspects of blockchains, is that you can have thousands of nodes, say, on the Bitcoin chain, and they all constantly communicate with each other to verify that, yes, what we are adding to the chain is what is appropriate to add at this point in time in this order. And we'll get into how they do that. Next slide, please. So data is structured on blocks with the data, which is the transaction details. So say I want to buy you know, paper on Amazon for 1 Bitcoin. That data, the transaction, me giving Amazon 1 Bitcoin, is the data. There is a hash, which is a unique identifier created by cryptographic algorithms. It looks like a string of purely random characters. It's used as a security key to say, you know, when I did this transaction to Amazon, it creates the hash that verifies, yes, this money did happen. This transfer did happen. And here is a secure identifier that indicates this was a true transaction, that I sent the money and Amazon received the money. Hashes are very important. They're highly technical in the field of cryptography, so I won't go into the math of how they are generated. However, by current technology and understanding right now, they are not able to be backwards engineered. So once you have a hash generated, there is no way to fake it, and it is there to signify like truth. Each block also has the prior block's hash. As you can see from the diagram, the hash moves on to the next block. That is to show linearity and that the blocks are occurring in the proper order. So if you see, if the nodes look at the chain and say, hey, you know, this block doesn't have the previous block's hash, they might have been added out of order. There might be something kind of funky going on and signal like a security issue that the nodes can work together to address. All right, next slide, please. So nodes work through consensus mechanisms. These are just agreements among all of the servers storing the data on the state of the chain. They just say, hey, do you have all these blocks? I have all these blocks. Are they the same? Great, we're functioning perfectly. There are two types of consensus mechanisms. The most common type is called proof of work. This uses pure computational power to solve incredibly difficult math problems. Once the math problem is solved, a hash is generated, a block is added to the chain. This is what you typically see with concerns about energy usage and hardware usage that other environmental concerns you see with blockchains. That's because of the proof of work math that is going on behind the scenes. A newer consensus mechanism is called proof of stake. It's ownership of the currency. You vote based on your stake in the chain and on the legitimacy of a new block based on really intense cryptographic validation algorithms. Proof of stake, PhDs are awarded for methods of voting. This is a lot of complex math, but it's less hardware intensive than proof of work. Next slide, please. So transactions are just initiation. You create the transaction, broadcast to the network, validation, and addition to the chain by the consensus mechanisms that I talked about in the previous slide. This is just, hey, everything happens one at a time linearly. Make sure there's a consensus and do it in order. Next slide, please. Real world applications, like I said, you've got cryptocurrencies, you've got smart contracts, which in contrast to what contracts look like to a lawyer, so like if my property value exceeds $200,000, sell it. It automatically happens. There's no need for escrow. There's no need for human intervention. It takes funny business out of transactions. You can also do supply chain management. You can, every time a product changes hands in the physical world, you add a block to a chain that says, hey, it went from provider to packager to shipper to customer. And that chain of command, or sorry, chain of management is clearly visible on the chain and immutable. Next slide, please. So some challenges are scalability. Transactions are incredibly slow. Some transactions can take up to 10 minutes because they are validated and done in a linear fashion. Regulatory concerns, compliance is difficult to ensure, especially because nodes are often housed on servers in various jurisdictions. So making a law in one country may not affect all of the nodes of a chain. And energy consumption, as I said, proof of work requires huge amounts of energy and hardware. There's precious metals and graphics cards that constantly melt and burn out when you generate blocks. And the electricity is a huge concern. This is largely being solved by proof of stake instead of proof of work, but the effects are yet to be seen. Thank you. That is pretty much all I have. If you have any questions, please let me know, but I wanted to give just a quick surface level overview of what this technology entails.
Excellent. All right. Thanks so much, Catherine. Fascinating. I feel like I still have a lot to learn, but at least I got to start with it today. Very complicated stuff. So really appreciate it. We're going to move on now to commercial financing transactions with another associate here in our Syracuse office, Haley Willett. Thanks for being here, Haley.
Thanks for having me. So part of what I do in the property department is work with commercial financing transactions. We represent both borrowers and lenders, but it's representing the lenders that really helps us know how to best prepare as a borrower by knowing what we're waiting for as lenders counsel. So I'm going to focus on the borrower side of the transaction and how you can kind of prepare in advance and make this a smooth transaction and a quick of a timeline as possible. So on the first slide, these are just some bank items as lenders counsel. We don't typically review them, but the bank will need them. So compiling borrowers' financial statements, tax returns, pay stubs. They might look for a budget or ask that a new bank account be opened, which will require additional paperwork. compiling those documents in advance, knowing where they are, having them ready to send to the bank is very helpful. The bank's also going to order an appraisal and do an environmental review of if there's real property involved in the transaction. So that'll be, coordinating someone to be available at the location as soon as possible, and coordinating with the appraiser in order to complete those processes and have those checked off the bank's checklist. On the next slide, insurance, the bank is going to want to make sure that all necessary insurance policies are in place. So the borrowers can figure out who they're going to talk to with their insurance agency, who is going to be their contact, providing those binders and certificates of their insurance policies, adding the lender as a mortgagee, lender's loss pay, and additional insured. It's very common that the first draft of these binders or certificates that we see don't have all the information on them. So there's some back and forth between lender's counsel talking to the borrower's counsel, getting back with the insurance agency, getting a new draft of a binder and certificate. So getting those initial ones as soon as possible is very beneficial for speeding along the timeline of these insurance requirements. Occasionally, the lender might look for a copy of the full policy. So finding those or contacting the agency or carriers in advance is very helpful. Next slide, please. One big borrower component is compiling the entity documents for the borrower's organization. So that's just lists of what lenders counsel will want to see for either an LLC or a corporation. The borrower's counsel will help preparing things like the resolutions and obtaining the good standing certificates and the franchise tax search. But the articles of organization, operating agreements, bylaws, organizational charts and EINs, those are, we have to rely on the borrowers in order to compile those documents. And on the next slide, thank you, are just some things to consider while getting all of these documents together. Are they up to date, and do you have all of the amendments and the most recent versions of everything? I've gotten to a closing where all of the loan documents are signed. We were lender's counsel, and we found out maybe the day before closing that the operating agreement we were given was not the most recent version. There was actually an amendment. It changed the party that needed to sign the documents. So it was kind of a headache to scramble to fix all of that at the very last minute. Which could have been avoided if we knew at the beginning what the most recent version of the operating agreement was. Lender's counsel will need to see certified copies of documents like articles of organization or the certificate of incorporation. So if the only copy you have on file is what was drafted and sent to the Department of State for filing, we'll need to request a certified copy from the Department of State. So knowing that in advance is helpful. Figuring out what state it was formed in, and if you're going to need some sort of authority to do business in the state that the company will be operating in. It's just another filing with, a different Department of State, but the lender's counsel will need to see that as well. Biennial statement filings. I think about half of the certificates of good standings that we see come through on these transactions have past due biennial statement filings. It's not a big deal. The filing just needs to be done, and then a new certificate can be ordered. But there is more back and forth, having to review it, getting the new statement, waiting for the filing. So having that done at the beginning definitely speed things along. And then figuring out who is authorized to sign on behalf of the company and what is that person's availability. sometimes it's only one or two people that can sign these loan documents. Are they available? Are they going on vacation? Will they be in town? Are they traveling? Knowing that in advance as lenders counsel can definitely be worked around. We can get signature pages out in advance, so all the documents are signed based on the signatory's availability, and then they're just held in escrow until closing. And they don't have to be available or in town for closing as long as we know that in advance and are able to coordinate. Next slide. So then just some collateral documents and searches. If there's real property being used as collateral, the lender will need to review a survey. Getting that ordered as soon as possible is very helpful. Surveyors are at least a month out now, maybe up to 2. I had a survey take 6 months recently. So getting that handled right at the beginning is very helpful to speed these along. Finding documents like prior title insurance policies or an abstract if it's in your possession, property tax receipts, other types of collateral, leases. We are very frequently as lenders counsel waiting to receive copies of all of the leases, amendments, extensions, basically showing the chain of any old leases and how it's currently in effect. A lot of those documents get misplaced. And then we also need tenants to sign certain documents. So coordinating with them, reaching out to the tenants to let them know that they'll need to sign something, getting them copies of those documents as soon as possible. And then there'll also be searches that are performed to make sure that there's no outstanding UCC financing statements, bankruptcies, tax liens, judgments, and litigation. So if there is anything open, the lenders counsel will need to obtain more information, especially in terms of litigation. So if the borrower is currently a party to any lawsuits, even just a summary of what the lawsuit's about, getting ahead of that. I am working on a transaction now where the borrower just kind of, hey, by the way, we're currently engaged in ongoing litigation, but don't worry. Well, as lenders counsel, we do have to worry about that. So, we need more information. Knowing that 2 months ago when the transaction started would have been very helpful. That's kind of just an overview of what borrowers can do to prepare and speed along the timeline of these transactions.
Great. Thank you so much, Haley. Appreciate it. And that's all we've got for today. On our next slide here, you'll see our contact information for all our presenters if you want to reach out. Also a reminder of our sexual harassment prevention training that's available. We're getting towards the end of the year. And if you haven't done your annual training yet, it's a good time to get going on that. Thanks, everyone. I'll be back here in 2 weeks. Gabe will be back next week. Take care.